Welcome to Intellectual Property Issues in Church 2024. My name is Scott Carpenter, and this is a presentation of the Carpenter Law Firm here at noon in Arizona. Welcome. This is not a topic that gets discussed much in the legal realm for churches. I'm going to hit a few of the highlights here today. For those of you that might be interested in how we deal with intellectual property, first is, what is intellectual property? I'm going to hit the highlights, really three things that we as lawyers deal with in the intellectual property realm legally. The first is patents, and the second one is trademarks, and then copyright. We're going to kind of run through all three of those in the church context. So first, let's start with patent. A patent is a type of intellectual property that gives the owner the legal right to exclude others from making, using, or selling an invention for a limited period of time in exchange for publishing and enabling disclosure of the invention. So if you invent something and you obtain a patent, you take your patent application to the U.S. Patent and Trademark Office, USPTO, and for a period of time, you have the exclusive right to make money off of it. One thing we know for obviously you know this, if you work for a technology company, let's say you are an engineer and you go to work for Motorola, you might brag, hey, I worked on 4 patents for Motorola. You don't own the patent. Motorola owns the patent. And there's a legal doctrine for that called work for hire. It's going to come up later in the presentation. It's important in the church context, and we don't even realize it in the church world. Work for hire becomes extremely important. But in the patent context, if you know an engineer, if you are an engineer, or if you work on complex machines or technology issues, you understand patents, and there are a lot of smart people who end up in their career working on patents, or even saying, my name is on a patent, but they don't make any money off of it because of the work for hire doctrine. So patents do not come up in the church context much at all, and it's not really going to be part of our discussion today, except we will revisit this work for hire context. Trademark. This does come up. A trademark is a type of intellectual property consisting of a recognizable sign, design, or expression that identifies a product or service from a particular source or distinguishes it from others. The shape next to the Carpenter Law Firm in the upper right of this presentation, you might say, well, that's a distinguishable shape, perhaps. Have I gone to the trouble of trademarking that? No, I have not. Could I? I could. And so trademark does come up. You're familiar with this R with a circle around it. That denotes that a trademark is registered with the USPTO, the U.S. Patent and Trademark Office. The TM, superscripted, raised above the other letters in a line, that denotes an intent or belief that the mark is unique or is in the registration process. So some people use this to suggest, I believe this is distinguishable, but you'll note that I have not placed the TM above Carpenter Law Firm or the shape to the right of the words Carpenter Law Firm. Perhaps I'm not that concerned about it, although I did pay a designer to create that for me as I launched the Carpenter Law Firm a few months ago. So it's important, but I obviously own the mark Carpenter Law Firm and the shape next to it. And if somebody were to use it, I'd still have the argument that they've stolen it, regardless of whether the TM is there or not. And then the third one, as I mentioned, we've got patent, trademark and copyright. What is that? Well, a copyright is a type of intellectual property that gives the creator of an original work or another right holder the exclusive and legally secured right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. Sometimes we hear, well, the copyright is expired on that story or that original work or that song, and now it's in the public domain. Well, that can happen, but copyright is sometimes denoted with this C in Microsoft Word. Left parentheses, C, right parentheses creates this C with a circle around it. And sometimes when you're typing, you create this accidentally. If you do a lot of typing and what you do, this can happen and you don't mean for it to. But when you type that or use it in your work, it denotes an intent or belief that the work is copyrighted by the author. So we do deal with this a good bit in church work. So our discussion today will center around trademarks and copyrights, not so much on, excuse me, not so much on patents. So in the years that I've been working with churches and nonprofits, we've had a number of skirmishes with others in the trademark and copyright arenas. Lawsuits, demand letters, demands for payment, and other types of disputes and issues that have come up. And I will generically try to address some of those to give you an idea of what can come up in the church realm. So this symbol here is a public domain example of a symbol that could be trademarked. Now, this is just a generic right-click copy from the internet, but it gives you an example of how we can get ourselves in trouble. I was careful that I did not reproduce something in my PowerPoint today that's someone else's intellectual property. Now, somebody created this, but I was careful to double check that it's in the public domain, clip art sort of, if you will, and not something that somebody could say, well, I own that, and you owe me money because you placed that in a PowerPoint that's in a YouTube video, a video that's posted on YouTube, connected through the carpenter.law website. I don't want to create the exact problem that I'm talking about that churches sometimes create. So trademark issues with logos. Now, I just talked about the Carpenter Law Firm logo, which is on every slide of this PowerPoint presentation. Churches have logos, and I'll create a silly one, 123 Mulberry Street. I'm sorry, not 123, Mulberry Street Baptist Church. When my wife and I graduated from college and got married many years ago, we just celebrated 33 years of marriage, and happily married, of course. And I shouldn't say of course, it's not inevitable that people would be happy for 33 years, but we've been happy 33 years, and 3 daughters and 5 grandkids, and got married after college and went to Waco, Texas for me to go to Baylor Law School. And we attended a church named after a street, Columbus Avenue Baptist Church. So Mulberry Street Baptist Church. Well, or Mulberry Street Methodist Church, or Mulberry Street Presbyterian Church, whatever it is. Well, when the church is started and the decision is made to name it Mulberry Street such and such church, Mulberry Street Episcopalian Church, somebody might come up with a logo, and it might be Columbus Avenue, it might be Mulberry Street, it could be McClintock, could be Scottsdale Road. When that person comes up with the logo and it becomes part of the the branding of the church, if you want to think of it that way, and the look and feel of the church and how it presents itself to the community, a decision has to be made. Do we care if that logo is trademarked or not? It's an important first decision, because if you don't care, then there is a risk that someone else could use the logo or the look and feel of the logo and use it for something else, or create another church using the same look and feel of the logo. So it's really more of a hypothetical question. Do you care? Would you care? And the hypothetical question is, you take the time and the energy or the money with a professional designer to create the look and feel of your ministry enterprise. Ask the hypothetical question. We spent the time and the energy and the money with the professionals to design the logo for the look and feel of our ministry enterprise. Would we care if once we present this to the community, if another enterprise takes the look and feel and the energy of what we've put into this? It's not just the money, the time and the energy and the effort and the money, and reproduced it for another enterprise, not just in the same community, but in a city across the way, another place in the state, another state next door, another state across the country. Would you care? And if the answer is no, we wouldn't care. We're putting it out there, and we would be flattered if someone copied it. Then really none of this actually matters then, at least in the logo context, it wouldn't matter. You might have a ministry specific logo. You might have a church where you say, well, we have a high school ministry and we're going to create a branding around our high school ministry. We believe in the future of or the future is the youth, and we're going to create an energy around the high school and the youth ministry, and we're going to brand it a certain way, and we're going to have a logo and a trademarked energy around the high school ministry and the youth ministry. We're going to put a lot of energy and effort and time and money into that logo. And we ask the same hypothetical question. If somebody takes it for the youth ministry down the street, or at another church or ministry in the same area, or in Tucson, or in Flagstaff, or in another city, or in another state, would you care? And if the answer is no, then you're putting your logo out there into the community at large, and you wouldn't care. So you wouldn't care to trademark it, and you wouldn't go to any effort. Maybe the church name matters to you. Maybe you care that Mulberry Street Presbyterian is a name that you would want to be reproduced somewhere else. Maybe the street is a bad example. But whatever the name is, if the name is Long Life Community Church, I just made that up, never heard of a church called that. But just making something up, something that is not location specific, has nothing to do with the city, has nothing to do with the state. And it's just simply Long Life Community Church, something that could be plopped down in any city or any state in the country. Would you want that to be trademarked? And along with a logo? And if the answer is no, I wouldn't care, then none of this would actually matter, and you wouldn't trademark it. The other thing that comes up from time to time is when a church is named after a subdivision or a subdivision area. Some examples include very large subdivisions. There's a very large subdivision south of Tucson called Rancho Sal Rita. There's a large one north of Phoenix called Anthem, and you might Think of a high-rise condo where a church might affiliate with the name of that because it's so big that it kind of defines an area. And I can't think of one off the top of my head, but you might have a subdivision that's so big that essentially defines an area. And what can happen in those situations is that those subdivisions become territorial about their trademark, or the developer believes that the developer owns the trademark, or the builder believes that the name of that subdivision is the intellectual property of the developer or the home builder. And I do a good bit of work with community associations, and I don't necessarily want to take a position in this educational environment today in this webinar about who would prevail in that situation, but there are some arguments that end up happening in some of those situations where you have a large subdivision name, and then all of a sudden a dentist or an insurance broker comes along and says, well, I'm going to be Anthem Dentistry, or I'm going to be Rancho Sal Rita Insurance Broker. And then a community of believers comes along and says, well, I'm going to be Rancho Sal Rita Community Church. And now there's some tension between whether the developer owns the intellectual property to the name, or whether that belongs to the community, and whether a community of believers can organize a church around the name of the area. And so we've got some issues that can come up and tend to be somewhat challenging to resolve when a community comes together, community of believers comes together and says, we're going to form a church and name it around the subdivision that's popped up in the desert, and we're just going to name it that way. We've also had some issues over the years where churches have endeavored to attract university students and have attracted some trouble from universities who say, well, the university logos are owned by the university. That's our trademark. And all of a sudden, the church that might use the university logo to attract students end up on the receiving end of demand letters and other challenges from a university. So we've got to be careful about some of those challenges. So trademarks can be challenging, both in terms of whether the church cares to protect its own marks, which is not all that expensive necessarily to participate in the US Patent and Trademark Office process, but also to be careful not to offend other trademark holders' rights, which protecting your own marks and asking the hypothetical question, do we care that much about our own marks? And how careful are we being about not infringing on trademark holders that we've got to be careful not to offend? And sometimes what churches struggle with as they get bigger is controlling all of the people who might be in a position to offend someone else. And so the question becomes, who's actually has access to the website, who has the ability to place things on the website, and who's capable of posting on social media and pulling pictures and promoting different things, kind of on this last point where we can kind of get into trouble sometimes. Let's talk a little bit about copyright. By now, hopefully most churches are aware of the requirement to license the music that's used in worship services and used by the church. Hopefully we're not making those mistakes. There's a website where churches pay a licensing fee to participate in licensing copyrighted music for use in worship services. I'm hoping that we're not making those mistakes. Let's come back to the work for hire doctrine and revisit that for a few minutes here. My father-in-law was a pastor for nearly 60 years. And one of the things that really defined his years as a senior pastor was his preaching, his preparation, and his ability to manuscript a sermon, and his expository style. And one of the things that would have been shocking to him if we had ever had the conversation before he passed away 5 years ago would have been, and I never did this, never would have dared to do it, is if I had ever had the conversation with him about the work for hire doctrine. He believed, as evidenced by his files in his personal office and in later years on his computer, that his sermons belonged to him. His papers, his manuscripts, his PowerPoints. And this is understandable because they came from his hours of study, they came from his brain, and they came from his effort and his writing, and they came from his work. Really no different than the engineer at Motorola who invented some chip or something else that ends up creating a patent. Somebody could convince themselves, I own that. I mean, it's really no different than anything else. And for him to believe that he owned the sermons would have been easier for him to believe because he literally had possession of the manuscripts and the Microsoft Word files and the computers that were in his house, in his personal office. So the work for hire doctrine would have been extremely difficult for him to get his brain around in the context of, hey, the churches that you were employed by over the years actually own the intellectual property and own the sermons, all of that content, all of the times that you preached through the Bible. The content of those sermons is actually owned by the churches. And if we had ever talked about it, he would have said, well, that's actually not practically or physically possible because they don't have the data. They can't own it because they don't have it. I have it. They don't have the computer files. They don't have the paper data before it was all computerized. I didn't leave anything there before I moved on to the next assignment or the next posting or the next place that I was called. And so, Scott, this hypothetical conversation we never had, I'm making it up for you. I can appreciate what you're saying in a theoretical sense on a whiteboard. I guess we could kind of create that, but they don't have it. They can own it in a law school professor sense, but they don't have the stuff. I have it. So, Scott, father-in-law to son-in-law, I'll concede the point that they own it under a work for hire doctrine that I feel like you're making up just to mess with me in this father-in-law, son-in-law conversation. But it doesn't matter because they don't have any of the stuff. And it's all my work product. I don't think anybody else could make any sense of it anyway. So, okay, the church owns the sermons. and will concede to the point in some kind of philosophical sense that the work for hire doctrine says in a default scenario, church hires a preaching pastor, a teaching pastor, a senior pastor. The church owns the servants. That's the default. If the church hires a musician who creates original music while employed by the church, and that's part of the expectation, then, and it's performed at the church, by default, the work for hire doctrine says the church owns the music. Now, the composer, the writer of that music, is probably going to say, you have to be kidding me. That's not the way I think of it. Came out of my brain. I don't have office hours. We have rehearsal on Wednesday, lead music on Sunday. I did this on Saturday. I did it Friday night at midnight. And we never talked about it. How does the church own the music? Like, well, we don't really want to get in a big fight about this. And so for many churches, it literally just never comes up. And the worship leader, the author, the composer owns it almost by the fact that it never comes up. Is it valuable? Sometimes it actually is quite valuable. Some of the most prolific creators of Christian music these days are on staff at some of the bigger churches in the country. We also have the issue of volunteer created ministry materials, and they're not being paid. So the work for hire doctrine feels a little different than it does with a paid senior pastor or a paid music leader, worship pastor, whatever word you want to use for that. But by default, a volunteer charged with creating ministry materials, the work for hire doctrine would still apply. The compensation piece is not that important to differentiate it from the work for hire doctrine. And then we get into some other trickier issues. The senior pastor is doing podcasts. The youth pastor has started monetizing his or her social media feed. And then all of a sudden there's advertising because the youth pastor has 1 million followers getting paid by TikTok or YouTube, Instagram. What's happening with that? This social media feed is being, the discussion among church leaders, the lay leadership team and the senior pastor about the youth pastor is, hey, the social media feed is bringing more youth to the youth group. That's what it's doing. And then all of a sudden, it's got 100,000 followers, 200,000 followers, and nobody's asking any questions. Are they in the local area? Or is this youth pastor all of a sudden becoming famous all across the country? Is the youth pastor monetizing the social media presence and making money off of it? Well, he or she's not going to tell you about that. And is this the work for hire doctrine? Under your nose, maybe the youth pastor is doubling his or her income from the church by monetizing the social media feed that was started out as, hey, I'll just raise my profile in the local community and bring more kids to the youth group. And all of a sudden, the youth pastor, the youth leader is monetizing the social media feed. And the same thing could happen with the podcast, where the advertising is becoming significant. I'm not saying any of those things are bad, but these things can happen right under a church's nose, and it's an employment issue where we need to be thinking about these things as a legal question up front within the employment relationship. And then another example of a copyright issue, and I'm going to wrap all this up at the end, is copying pictures from websites that are not part of the public domain. I alluded to this a few minutes ago. We've got to be very careful about what happens with website construction when we're dealing with issues that are not part of the public domain. And actually, we should be kind of concerned about the assumption that a picture is part of the public domain when it may not be. So I've got a few takeaways, and we'll wrap a little early. My endeavor with these seminars is to keep them under 59 minutes. I'm going to do that successfully today. So here are a few takeaways. Websites are constantly monitored for stolen copyright images. I've had a number of clients who have received demand letters because websites have been monitored for copyrighted images. And when these things happen, sometimes the easiest thing to do is to just pay the licensing fee, pay the penalty, and move on, because the costs and legal fees to fight it, it's easier to pay the licensing fee and move on, because we're wrong. That's part of the problem with some legal disputes is when you're wrong, what's the point in litigating it? You have to concede, yes, it's copyrighted, we were wrong. That's something we kind of have to do. So here's the suggestion. Website construction and updates should be done by professionals who are not going to copy and paste from other websites. And this is where we end up with websites created by somebody's son-in-law or a homemade version. We're actually increasing legal risk when we do it that way. When I started the Carpenter Law Firm a couple of months ago, it was one of the first things you do when you start a new venture, whether it's a church or a law firm or starting a restaurant or any other business, is you ask yourself the question, can't I just go to GoDaddy and do a homemade website? Or do I need to hire a professional and actually spend money when I think I could probably piece it together myself? That's one of the first questions one asks oneself. It doesn't matter if it's a church or a dry cleaner or a restaurant or a law firm. We all do the same thing. But in my case, and in the case of a church, there's a lot of protection that's created legally when you hire a professional, because a professional is not going to make the mistake, let's assume, of using pictures and other content that's copyrighted. They will find pictures and other content, and if a licensing fee has to be paid, professional will tell you we've got to pay the licensing fee for that image. That's been my vast experience, is that's one of the things that you obtain when you hire professional website and content creators, and what you lose when you ask your son-in-law, and I've got the world's best sons-in-law, and I'm not disparaging them, of course, but just the placeholder for somebody in your personal or network that thinks that, oh, it's easy, I can just do this real quickly. There's plenty of websites that help you create websites. Is you end up with this cutting corners dynamic. There are companies that make money doing nothing but trolling for copyrighted images on websites that don't have the licensing. And they use web crawlers to find these unlicensed images. And that's their sole way of making money, is finding images that are not licensed and then sending demand letters. And there are lawyers whose sole purpose as a law firm is to help these companies extract these licensing payments. And I've had clients that have encountered both the companies and the law firms whose sole purpose is to extract these penalty payments, if you want to call them that. And plenty of these clients that have encountered them have been churches. So we need to register the trademarks that you want to protect, the church logo, the ministry specific logo. And the easy rubric is, do we care? Do we care if somebody takes our logo? And if we don't, then we don't need to worry about it. And your status quo may be that church name, that ministry name, that logo is not registered. Okay, somebody could take it, reuse it. Maybe we don't care. But if you do care, if somebody were to pop up in San Diego with your church name and logo, and you don't care, San Diego, San Francisco, San Mateo, San Antonio, whatever, and you don't care, then we don't need to worry about it. But if you would care, then we probably need to have a chat and get that registered. Now, here's where we can solve the problem of the work for hire issue. If the creative professionals and authors, whether it's your senior pastor or your teaching pastor, if they believe they own their work product, like my father-in-law, then we can easily create an agreement that flips the work for hire dynamic and vests the ownership of their intellectual property in the author, him or herself. We can go back to this right here, and we can take the work for hire doctrine and we can say, all right, Scott Carpenter's father-in-law, we understand that you believe you own your sermons over 50 years. You have possession of them. No problem. Here's a one-page agreement that acknowledges that you own the intellectual property of your sermons. Now, the truth is, in my father-in-law's case, it would have been in this hypothetical conversation we never had. I emphasize that. This is a conversation where I know how it would have gone. I know it was important to him. We never had the conversation. I'm revisiting it now from 10 minutes ago. If all of the churches where he created these many sermons, if they could all at once release their intellectual property claim that he would have acknowledged in this hypothetical conversation that never happened, that they had this work for hire interest in, if they could have all released it at once, what would have happened? Would he have been in a position to assemble all of those sermons into a series of books and publish them? And, turn it into the next 10-volume set of commentary? No, frankly not. But it would have been an important acknowledgement that he owned it. And so for some pastors, whether the pastor is in a position from a time standpoint or an energy standpoint to do anything about the ownership of the intellectual property is irrelevant to the acknowledgement that the effort and the time and the intellectual investment in the work product belongs to the person putting the work in. And so sometimes there's an intangible appreciation by the author that the church has acknowledged that the creative person who's done the work owns the work product from an intellectual property standpoint. And that can be meaningful to the person who's done the work, whether it's going to result in anything other than the author saying thank you for acknowledging that I'm the one who did the work and that I own it. I can't predict. I can only assume that many pastors would appreciate that. All right, one other, so that's kind of how it ends up. I do think that there's this podcast and social media feed issue. We're going to see more of that. I'm not sure how that's going to end up as people want to be influencers and end up on church staffs and develop more and more of a following and end up with this supplemental income. I'm not. We could still do that agreement with them that they can keep all of that supplemental income. There are some churches where the senior pastor makes more money from book publishing than from their salary as the senior pastor. And this has been a trend over the last 20 to 30 years where that's got to be documented. And if there's an attempt or belief that the senior pastor is going to publish, it's this last bullet point where that has to be reduced to an agreement where the pastor is going to be publishing work product. The work for hire doctrine would say that book belongs to the church. There has to be an agreement that book is owned by the pastor individually and is not part of the work for hire doctrine. That's an important part of it. So quick highlight here, July 18th, we will talk about employment issues in church. Because I've just covered all of this topic of work for hire and these copyright issues will not be a big part of it, although other employment issues will be a part of what we talk about on July 18th. Questions, because this is a webinar format, we're using the Q&A feature. IRA compensation issues and inurement. IRS compensation issues and inurement. That is a good question because churches are 501c3 tax exempt organizations. There is a prohibition against a church creating private inurement, which is essentially, it's kind of a weird word actually in the church context. And so what we end up with is it's a prohibition in the tax exempt world that a pastor and other church executives cannot get rich on the back of a church or a tax exempt organization. And it really goes back to Jim and Tammy Faye Baker in the 80s, where they abused the tax exempt organization to essentially get rich off of their real estate development stuff in the development. And their idea was, well, we weren't in the room when they set our compensation. Well, they had meetings before the board meeting and essentially manipulated all the compensation. So What we're worried about with private annulment is that the organization cannot set the pastor's salary at $2 million a year. So what has happened over the years is that the pastor in Houston, who has the huge church there, I'm blanking on his name at the moment, the smiling pastor, whatever his name is, it doesn't matter. He's made so much money from book publishing. Well, the way that this has worked out under private annulment is that the church may pay him a small salary, but he makes all of his money on book royalties from his publishing. And the same thing is true with the pastor of Saddleback Church in California, where the pastor, Rick Warren, received, he's retired now, as I understand it, a small salary from the church, but made a tremendous amount of money in royalties from publishing his books. And the 501c3 private annulment is all about what's happening inside the nonprofit 501c3 tax exempt organization, and the small salary is an acceptable way to comply with tax exempt requirements. There's no private annulment because Jim and Tammy Faye Baker had huge salaries inside the tax exempt organization. But when the book publishing or podcasts or social media feeds and 10 million followers getting paid by TikTok and Instagram and all of that, when all of that is inside the tax exempt organization, then we have private annulment problems. But when the revenue is outside of the tax exempt organization, then everything works out to be okay. Okay. Well, that's intellectual property issues in church. Just want to emphasize, not patent, trademark. What marks do you care about? Logos, and on copyright, work for hire is really the big thing. And are we keeping track of who's creating content? The work for hire doctrine. And as always, we're here at the Carpenter Law Firm for any of the legal issues that you might have at your churches and ministries. If we can ever be of assistance for you, please let us know if we can help. And have a great rest of your day, and hopefully we'll see you again in July. Thanks. Have a great day.